Hello and welcome. I'm Ed Cohen, and I'm delighted that you're here. I'm a partner at Thompson Coburn. I'm also a mediator with Miles Mediation and Arbitration, or on Miles Mediation and Arbitration's panel of neutrals. The checklist that I want to talk to you about today is sort of a combination or compilation of my experience, most of which, for most of my career, has been focused on helping people, clients, address and resolve environmental disputes. And so this checklist is a combination of things I've put together from my experiences through mediations and through litigation, but mostly focused on how to address and resolve environmental disputes. Before I dive in, there's two things, and I have a lot to cover. So as I said, I really like to talk about this. So I'm anxious to dive in, but there are two things I want to cover. One, I'm just recovering from a ridiculously long cold. I'm just getting my voice back. I apologize to you in advance if my voice starts to get even more hoarse than it already is. The good news is any available throat remedy that they sell at Walgreens or CVS is within arm's reach of me on one side, and coffee, tea, and water are on the other side. The only thing I'm missing is chicken soup. But if I have to go and grab one of those during this presentation, I apologize. That just couldn't be helped. So just bear with me with the hoarseness. Secondly, there is a script for the CLE for people who are wanting CLE, and so I need to just read that. Let me just plow through that, and then we'll dive in. If you have questions during the webcast, you can submit those through the Q&A widget. I call it the box, or just click on the Q&A thing. Secondly, if you have questions or technical issues, you can also click on the Q&A. Hopefully, somebody who knows more about technology stuff is online and will help you with that momentarily. And excuse me for one moment. Sorry. A copy of today's slide deck, which I'm going to go through in this talk, is available in the resources widget or block that you have. And I do hope you'll download that, and feel free to do that. I hope you'll find it interesting. I have a number of links at the back of various articles and things related to this. As I said, I really like talking about this topic. There's also a help widget if you need technical help. Hopefully there's someone online who knows a lot more about the technical side than I do. Today's webinar has been approved for 1 hour of general credit in California, an hour of credit in Illinois, general credit, 1.2 hours for general credit in Missouri, 1 hour of professional credit in New York for experienced and transactional lawyers, and 1 hour of general credit in Texas. And it's CLE is awarded based on full-time attendance, and during the course of this talk, as part of the CLE requirements, I will give out certain passwords. Don't worry, I'll make it real easy. And then you can click on those and it verifies your attendance. And at the end, in case I forget to say it, to the extent you're willing to submit a survey and give us feedback, I sure would appreciate that. Okay, let's dive into the good stuff. So as I said, this is a checklist. And the idea of a checklist, I've always liked checklists. I think I first started using checklists many years ago when I was on active duty, and found them very useful. So in this case, as I said earlier, I've tried to use my years of working on environmental issues to come up with this checklist, but I want to talk about why. But first, the concept of this checklist, I do think people who do a lot of environmental work, you're going to know everything that we're talking about. The reason it's in a checklist is because of the fact that a lot of environmental cases, and I'll talk more about this in a minute, find themselves heading towards a mediation because parties want to try to resolve them early on before there's been a lawsuit sometimes, and before there's been discovery. And as a result, a checklist, even though you know all these topics, helps run through these things to help the parties be more prepared when they get into the mediation. Or as I sometimes call it, giving your mediator a chance at getting it resolved. It's just the more preparation you do on these issues, the more likelihood you have of being able to resolve the dispute during the mediation. And that's the purpose of the checklist. So one of the first questions I get asked sometimes, as I said, I do a lot of speaking on this topic, is are environmental mediations, or is preparing for an environmental mediation different than preparing for any other mediation? And the best answer I can give is yes and no, or they're the same, but they're different. And as we go through this, I think you'll see some things that you would do in preparing for any mediation of any type of dispute. And there are other things, hopefully a number of things, that are unique to preparing for an environmental mediation. So why this checklist? Why am I talking about preparing before you go to the mediation? Doesn't everybody know to prepare before you go to the mediation? Of course, everybody knows that. But sometimes my experience has been, and I think the question sometimes comes up, do we get the cart ahead of the horse if we jump into a mediation too soon? And that is why I have this checklist, but I want to talk about the why. And the reason is because you can go into a mediation in an environmental dispute before you've done any discovery, which means you don't know all the facts. So if you go back to what I call the old days, where you'd have your lawsuit, you'd have motion practice, you do tons of discovery, you do summary judgment type practice, and then the court sets it for trial, and then the parties go and say, hey, judge, can we have a shot at mediation? Of course, at that point, you already know a lot about your case. You certainly should, because you're on the eve of trial. But in environmental disputes, experienced, well-intentioned environmental counsel know that these cases, if there's one being threatened, are going to cost a lot of money. And so what experienced counsel do correctly, and I encourage it, it's the right thing to do, is they try to get together with the other side, because even if they disagree on everything about whose fault and so forth and so on, the one thing they probably both agree on, if they're experienced, is it's going to be an expensive process to do discovery and to litigate the issues. And because of that, for good reason, before there's discovery, before we know all the facts, environmental lawyers try to get environmental disputes to mediation. And that's really the genesis behind this checklist, so that if you're in that situation, that you'll run through this list and hopefully have thought through these issues to help you get better prepared, to give you a better chance of getting the matter resolved in the mediation. And so what's one of the reasons environmental disputes get resolved, go to mediation to try to get resolved prior to there being a lawsuit or prior to discovery? The number one reason is because of the cost of litigating these disputes. Anybody who works in this field is aware of that. A second reason that comes up a lot, and maybe this one's more philosophical, but I think it's practical as well, which is if you're going to spend time devoted to litigation, that may be time and it may be money devoted or not devoted or taken away from addressing the environmental issue at hand. In addition, and I know there's a lot of government folks who've signed up for this or registered for this, so I'm delighted that you're here. This subpoint may not be as of interest to you, but private parties sometimes can realize that if they go and start poking a bunch of holes in the ground, doing a bunch of borings and doing a bunch of testing, trying to say, hey, this is more your problem than my problem. This is the one who caused this. In doing that fighting, they may be creating a lot of evidence that they kind of wish they wouldn't have created in the long run. Sort of a plain chicken approach, but that's more between the private parties. And the final thing I'll end on this slide is where I started on purpose, which is that the cost of litigation is why I think so many environmental disputes, why so many experienced environmental counsel try to get their matters to mediation or to some form of dispute resolution early on, well before they've done full-on discovery. And it's just because they know there are tremendous costs. The problem, of course, is you don't know all the facts. So what I tried to do in this checklist is put together what I think are common issues that I've seen come up in mediations or efforts to resolve disputes early on in environmental disputes. And there's really 5 buckets. The first 3 are probably, as I said, pretty obvious. What are the basic facts? What are the claims? What are the anticipated defenses? Obviously, if you were mediating on the eve of trial, you would know all those. But if you haven't had a lawsuit yet, you just have a threat of a lawsuit, you may not have fully thought through all these issues. They may not be fully vetted yet. Also, something that I think isn't solely unique to environmental disputes, but relatively unique, I think, to environmental disputes is, can you achieve finality in the lawsuit you're trying to resolve? Will that give your client finality? Is the matter over once you resolve this lawsuit? Sometimes environmental disputes are different because of complexities than if you had, I don't know, for example, a slip and fall at a grocery store. Person's hurt, they come in, they make a claim, you agree on a dollar amount, they sign a release that it's forever, that person goes away, and the two never hear from each other ever again. In environmental cases, as I'll talk about, that it's not always that way. And the final bucket that I'm going to talk about today is my sort of catch-all of things, which is insurance, indemnity, and contribution. And yes, those 3 can sometimes overlap and have common issues, but they're also really separate issues to consider in advance of the mediation. The only reason I put all those in one bucket is because I have them in a very, very general category, which is, can you find somebody else to help pay for all those costs needed to address the environmental dispute, to fix the problem? In other words, these are the bucket of, is there some other bucket out there, some other pocketbook you can help tap into to help pay for things? It's always good to know. So there's a hypothetical that I want to talk about, and I'll circle back to this, I think, several times in this talk today. It's a scenario that I see and have seen come up a lot in environmental disputes. Not everyone, but a lot. So here, the hypothetical is, property owner A was previously owned and operated by an old manufacturing company. So let's say they manufactured in the 40s, 50s, 60s, 70s. But more recently, this new company, because I'm not creative, I call Newco, purchases property A. Newco doesn't use any of those chemicals, and Newco's not even a manufacturer. They just own the property, and they bought it because they're going to build an office building, or did build an office building. And so separately, you have now property owner B, who is claiming or suing for, saying, contaminants that were used from that manufacturing company on property A are coming onto property B. This is a very common scenario in the environmental world, litigation world at least. So what are the basic facts? I said that was my first of the buckets. So obviously, if you're on the eve of trial, you already know what the contaminants of concern are. You know what are the chemicals that are at issue causing the environmental problem or the alleged environmental problem. But I have been to mediations, again, because counsel wanted to try to get there before they went to the expense of litigation and discovery, and counsel at the mediation were arguing which were the contaminants of concern. And so usually you know those. Sometimes there's just one, and that's very simple, but you don't always. And my point here is not just to think what you believe the contaminants of concern are, but in preparing to go to a mediation, think about what is the other side going to say the contaminants of concern are. A lot of times, one chemical, one contaminant will be the driver for the cleanup. But if you're arguing over which one is the contaminant of concern, which chemical is the driver, you're probably not going to get too far in that first mediation. One thing to think about as you're trying to figure out what the other side might say. Sometimes there's one chemical both sides assume is the main driver for the environmental dispute, but maybe there's a presence of another chemical in a smaller amount, but that it's much more expensive to clean up. So thinking like somebody who does work on the plaintiff side, maybe they're going to come to mediation and say, well, I'm really concerned about that chemical, and it's 5 times more expensive to clean up. That's why it's good to think about this. Again, if you're way into the case, you already know it. But if you're not in the case early on, it's good to make sure you think that one through. Relatedly, are these contaminants of concerns moving from property A to property B? Or have they moved? Or are they threatening to move based on modeling or whatever? And I don't have time to go down that rabbit hole, but it's an issue that as you prepare to go into the mediation, you should focus on and think through. A lot of times in environmental disputes, there's just the threat, and property B owner doesn't actually know what the status is of the contaminants from property A on its property. Or maybe they know a lot because they've been dealing with the regulators for the last 10 years. So there's a ton of information on these issues. My point is just as a checklist, you want to go through it to avoid surprises during the mediation. Okay, so we have our first secret word. It's not that secret. I'm telling you the answer. It's discovery. So again, this is for the CLE. Please click on discovery. Discovery is the secret word. I think it's also to give me a chance to catch my breath. Please click on discovery. Discovery is the secret word. Okay. All right. Moving on. Still under getting your arms around the facts before you go into the mediation. One question that's going to come up is, where are the contaminants of concern now? Are they on, just from the hypothetical earlier, just this property B, or have they dispersed to a nearby residential community? Are they in a water body? Are they someplace else? And it's going to come up, even though you haven't done discovery, and maybe you don't even have a lawsuit, it will come up in the mediation, I can assure you, of how did those contaminants get from A to B or wherever they allegedly went to. Did they get there by air stack emissions? Is it going to be that type of case? Is it from surface dust? Is it from surface water runoff? Is it from groundwater migration? Is it from storm drains or sewers or some other conveyance method? I have been in mediations, again, pre-discovery, where the parties are arguing over these issues. Related to that is the topic of, if it is a groundwater case, which direction does the groundwater flow? Does the groundwater even flow from property A towards property B, or does it go the other direction? Which way does surface water flow? Which way do prevailing winds? Which is the direction of prevailing winds? Related to this also, it's good to know as you go into the mediation, is the chemical that's really the driver for the cleanup, is it biodegradable? That impacts the remedy that can be used. It impacts the options. Or is it more of a quote unquote forever chemical or an otherwise persistent chemical? Those will affect damages. Those will affect remedies. Those will affect things that are very important at trying to get a case resolved. Related to that is the question of toxicity, and also are there human exposure routes? These also affect remedies and options that the parties have in trying to resolve it. Is drinking water involved? Is it a vapor intrusion case? Are people exposed on the ground? Are kids playing in soil that may have lead in it? Those, again, if you're on the eve of trial, you already know all that. But if you're going into a mediation prior to all that, the question is, the point is, from the checklist, to go through to make sure you're not surprised at the mediation, so you have your arms around this. The next thing is, again, same thing, sort of a broken record here. You would know what the claims are if you're on the eve of trial. But if they haven't sued yet, and it's an environmental case, a lot of people just have a knee-jerk thought, well, it'll be CERCLA. They're going to sue me under the Superfund law. That may or may not be true, or that may partly true, but not completely true. And my point is, when you're pre-litigation or pre-discovery, it's good to think about these issues before you go into the mediation. Is the basis of liability strict liability, or is it going to be a fault-based? Is the claim going to be pursued as a statutory thing, one of the federal environmental statutes or a state equivalent, or is it going to be a common law claim? My experience in many, many environmental lawsuits that I've seen and worked on in the last several decades have tried to use, and I think successfully used, both combined. And so that then is really good to think about, so you don't just think like environmental lawyers tend to do, oh, it's going to be Superfund, it's going to be CERCLA, and find out that they're going to be pushing on nuisance or negligence, because those impact damages and they can impact remedies. They also impact defenses. So, but the claims, are there going to be actual damages? Are there going to be penalties, which tend to more arise from either governmental claims or citizens' claims? Is there going to be a claim for remediation cost, reimbursement? Have they already spent this money to remediate their property and they're asking you to pay for it? Or is there going to be a claim because of common law where they can seek punitive damages? That also can be important to know before you go into a mediation where you're talking about dollars to try to resolve a case. Also, is the primary driver going to be injunctive relief? Are they going to seek an order? Is the party who's bringing the claim, or if you are the plaintiff, are you going to be seeking an order that the party you're suing has to do a cleanup on your property? And so that gets into a lot of other types of issues. Or is it a case where there may be personal injury claims or personal injury claims potentially such that there could be medical monitoring? My point is, you want to think through, or when you get to the mediation, are you going to hear about injunctive relief? It's good to think about all the things that may come up before they come up, and you have to address them by the seat of your pants during the mediation. Also, the federal environmental statutes allow for attorney's fees. So you need to think about, is this going to be a case where the other side's going to be seeking attorney's fees? Attorney's fees in environmental cases can be very, very, very substantial. Okay, what are the anticipated defenses? I've thrown a lot here, and frankly, this isn't a very good order of them. The first couple are more sort of fact-related type defenses that come up in a lot of CERCLA Superfund allocation cases, where someone says, hey, my client only contributed a small amount. We said, therefore, just have to pay a small amount of the damages or the cost of cleanup or whatever. Or they say, my client may have contributed a lot to that site, to that facility, but most of it wasn't toxic. Only a little bit was toxic, so you have to pay a small amount. Again, this isn't a CLA we're going to go down that rabbit hole. It's just flagging for you in advance of the mediation to try to think about what you're going to hear from the other side, or if you're the defendant or the party being sued or claimed against, what is it you're going to raise? An issue that comes up a lot in environmental disputes. Again, if you go back to our hypothetical, NUCO owning property A, even though NUCO doesn't use the chemicals that are at issue, NUCO just bought the property, but property owner A is the prior owner, is the one who may have or allegedly released the chemicals onto property B. Is NUCO the legal successor to the old manufacturing company? They may or may not be. This varies by state law. It varies by how the purchase and sale occurred, and it varies with some nuances that are kind of unique to the environmental world. Again, going down that rabbit hole is beyond what I can get to in these 50 minutes I'm going to talk. 50 or 60. But it's good to have on the checklist. If it's a CERCLA case, or if that's going to be one of the claims, are there CERCLA defenses? It's good to know that, and it's good to think through those in advance of going to the mediation, so you have a response to that. If the other side's going to say, oh, you're going to bring CERCLA, why I have a bona fide prospective purchaser defense. Again, I love talking about the different statutory and well-known CERCLA defenses, but the point here is just to flag them, to make sure you go through the process, either at the plaintiff side or the defense side, to see if they apply or don't apply, so you're ready for them, so you're not surprised. Also, even if you ask probably a first-year lawsuit, what's the first thing that comes to mind as a defense? If somebody is saying that their next-door neighbor spilled chemicals or released chemicals 50 years ago onto their property, probably most people, hopefully, will come up with statute of limitations. So statute of limitations are different in state by state for tort claims, and statute of limitations are simple and complicated, I think, in when they're triggered and so on, if you're dealing with the federal environmental statutes. Again, the point here isn't to do an expose on how statute of limitations work in every environmental case, but to flag it for you that in all likelihood, it's going to come up because it's one of those common issues that comes up time and time again in environmental disputes. Okay, I want to talk about coming to the nuisance for just a moment. It comes up much less often, I think, in my experience, than statute of limitations, but a lot of sophisticated lawyers who are representing parties on the plaintiff side will bring cases under a nuisance statute. Different states, the law varies by different states on whether coming to the nuisance is or is not a defense. In the hypothetical with property owner A and B, if property owner B is also a new owner and didn't own property B when the manufacturer is there, property owner, the owner of property B in that hypothetical I gave at the outset, if it's a new owner, could that person, if the main claim is nuisance, is there a defense to say, hey, you bought this knowing this stuff was here, you came to the nuisance. And so that's a defense, or can be a defense to a nuisance claim. Again, the point here is just putting it on the checklist. Likewise, in a lot of environmental disputes, the defense of federally permitted release comes up. And if you get to argue that, it's a great defense. It's a great get out of liability card when and where it applies. But it's not broad. I think it's relatively narrow, very important where it applies, but it doesn't apply to everything. It's really good to think through, is the other side going to have a claim? If you're planning to walk in the mediation and say, federally permitted release, we're not paying you anything. If that's your thought, make sure you think through whether the federally permitted release is the end all and be all for the litigation, or is the other side going to have an opportunity to get around that, an argument for getting around it. My only point is you need to think it through in advance because the issues get complicated. The other thing I want to talk about also could be a topic of an entire CLE is whether there is or is not joint and several liability for several liability. Joint and several liability is an incredible hammer. Parties that go to a mediation thinking they're only responsible for some small share, that's all they have to deal with, can be very, very unhappily surprised, if that's the right term, very frustrated to get there and find out that the argument against them is joint and several. So the other side is seeking tons more money than what they'd anticipated before going into mediation. And that can be a game changer. Joint and several liability can have dramatic implications. It can be the 400-pound gorilla. It's just, my point isn't that that's right or that's wrong. My point isn't that it's fair or unfair. My point is just you want to think it through so you're not surprised in the mediation. Okay, I mentioned earlier about finality, and I want to talk some about that. In government disputes, it's very common to have a reopener. And again, that's not a judgment thing. That actually makes great sense in the right kind of cases. So people who are used to dealing with governmental resolutions may end up with a resolution that includes a reopener. But the reopener also, if you're not used to that, means, just like it sounds, under certain circumstances, certain facts, the case may get reopened. So if you're working, trying to you've resolved something with the government and there's a reopener, and you're also now trying to resolve with private parties. And they say, like, well, what do you mean it's not over? Well, who would have signed that? It's good to have an understanding of the role of reopeners when you're going into a mediation, and the possibility that there might need to be a reopener to get everything for the current dispute to the finish line. Also, and this is another one of these topics we could spend the whole hour on, is will the settlement yield contribution protection? The CERCLA has a formula for contribution of protection, and it's very specific. State laws also have various ways to help ensure you get contribution protection. What you don't want to do in general as a defendant is to settle with somebody and then brag to your client, hey, that's a great settlement, now we're done. And then the next day get sued by somebody else for the same chemicals at the same site because you didn't get contribution protection. Someone sues you saying they paid more than their fair share and they want you to pay some more to reimburse them. Ironically, one of the few cases I've had go all the way to the Supreme Court was in a situation where I think our client's payment was $10,000, but the parties as a group had not taken all the steps to get contribution protection. So it's a long story, but we litigated over a whole bunch of $10,000 claims, a matter that went to the Supreme Court. They ended up not taking the case, sending it back to the Ninth Circuit, long story, but contribution protection is very important. And my point, again, isn't to answer exactly how it always works in every situation, but to flag it so it's on your checklist so that you go through the mental process of thinking about, do we want a settlement that will get us contribution protection? Would we rather not go down that path? What are the pros and cons? If we want it, how do we get there? And so related to this gets to the topic of, can there be further litigation? Obviously, if there's not finality, that's the other side, right? That's the other side of the coin. Can there be further litigation? So in environmental disputes, a whole other aspect of CERCLA can be natural resource damages claims. Those don't apply in every situation, but they do in a lot of situations. It's just good, again, for purposes of a checklist to run through, is there likely to be a natural resource damages claim? Separately, in a lot of disputes, the government has enforcing environmental regulations, either the state environmental agency or the US EPA is involved in litigation or claims or the administrative process with one or more parties before the private parties are suing each other. And in those situations, you may well resolve a dispute, hopefully to your client satisfaction with the government, and then turn around and get sued by the neighboring property owner. In the example from the hypothetical, property owner A, property owner B, NUCO resolves its issues with the government. It does what it needs to do, and it thinks like, well, now we're done. Well, not so, because the owner of property B may have wanted to build apartments or something on the property, and they can't because of the contamination that you're working with the government to get cleaned up or to address. They may have property damage claims. They may have other types of damages. They may have, in certain scenarios, bodily injury claims. Normally, not always, the government case comes first, then the private dispute, but not always. Sometimes the private dispute will come first, and then the government will get involved. Sometimes they're in separate paths, but going simultaneously. And so all of those make for a lot of complexities. It doesn't make it right or wrong. It's just good to understand that those are out there. In addition, as to further litigation, particularly if the government hasn't been vigorously enforcing something, maybe it's just been a private dispute between parties, can there be an NGO that could bring in some type of claim, a citizen suit claim? I love talking about citizen suit claims too, but this isn't the time to do that. My point here for purposes of the checklist is to make sure you know and remember and think through, go through the sort of the methodical process of recognizing that they may be out there or analyzing whether they may or be out there. And what's the reason for that? It's to manage client expectations. The worst thing, I think, is to get to a mediation and it's about 3:30 in the afternoon. You're getting close on the dollar amount to resolving the dispute that you're at the mediation for, only to figure out all of a sudden that you're very likely then to be drawing a separate private property owner suit or a separate citizen suit claim or a separate natural resource damages claim that never goes over well in a mediation. If at 3:30 the client figures out for the first time, because the parties figure out, there's going to be more litigation after this one. Again, this is on the checklist, and to give your mediation a chance of resolving it, you need to manage client expectations and go through the process, the thought processes, to see whether your case may or may not have these. Okay, I talked about this other bucket earlier. Excuse me, I apologize. Give me one moment, please. I don't know if that home remedy will help, but we'll give it a try. The last bucket I want to talk about, as I said, deals with insurance, indemnity, and contribution. And these three things can overlap in some ways, but they're also actually very separate concepts. The one thing they have in common is if you're a party that's trying to get insurance or indemnity or contribution, what are you doing? You're trying to get somebody to help give you some money to help you pay to address the environmental issues at hand. These separate, these concepts are complex. And earlier I mentioned that there's a number of government folks who have signed up for this, and I'm delighted that you're attending, and I hope you're finding this interesting. And this thing about helping someone else, having some other way to help pay, I understand at the threshold level for the government shouldn't matter in an enforcement action. I get that. However, a place where interests align between all the parties in a dispute is if you can find someone else to help pay, it may help get you to a finish line or do a better remedy, maybe a more costly remedy, if you can get insurance or indemnity or contribution to go forward. I think one of the most creative resolutions that I've seen in the last few years was a situation in which the government did the response action itself. So the government was actually paying for the initial work of remediating a site. And they were going after, the government was proceeding against certain PRPs, potentially responsible parties. And in this case, the responsible party was teetering on bankruptcy. And so the government ended up doing something I thought was very creative, which is they got what they could from, by way of commitments from that defendant, but they also, it wasn't technically an assignment, but they got the equivalent of an assignment of insurance policies so that the government had a stake in what the defendant's carriers may or may not pay. And so I found that very creative. And I know I probably sound like a big nerd, but I love working with parties to try to resolve issues using those kinds of things where the parties' interests align, even though they may not initially at the threshold, but they do. And so let's just talk about these concepts very generally. The reason the reason insurance comes up in environmental disputes is because it's always great if you can find some insurance company to pay for or help pay for cost of defense, or better yet, for the cost of the remediation. So how does it work in a nutshell? There are CLEs that go for an hour, they go half day, they go all day. I think there's some multi-day CLEs focused just on how do you get insurance to pay for environmental disputes. It's an area that's sort of a subspecialty in and of itself. So obviously, in my next 3-4 minutes, I can't go into those details and cover that. So I'm going to hit the super tip, the tip of the iceberg. So with claims like we have with the hypothetical of property owner A, where the manufacturer was there in the 50s and 60s and 70s, the first thing to know whether you might be able to get an environmental, not an environmental policy, an insurance policy, a general liability policy to provide insurance for you, is you have to go look for old policies. That may mean looking at old boxes with cobwebs and dust on them. Maybe you're lucky and somebody's put all those into some electronic form. Some companies are very, very different. Some are just in deep storage. Some have destroyed them. But the first thing is you have to figure out if you have some policies that you have a corporate relationship to that you can make a claim under. Then you have to figure out were those policies, say, from the 1950s or 60s, if you were lucky enough to find those. Do you... by the way, for folks with questions, I have time at the end, and there is a question and answer, so feel free to populate the question and answer, and I'll try to address those as I get through this. Anyway, so as the policies being triggered, one thing is, if you're lucky enough to find the old policies, are there incidents, releases, leaks? Are there facts that will allow you to argue that the policy in those periods, those policies were triggered? And so then you run into the thing that people hear a lot about in the environmental world, which is the pollution exclusion clause. So this depends on the time frame. The reason people who do a lot of this work like to look for the older policies is because prior to roughly 1972 or 73, the older insurance general liability policies did not contain pollution exclusion clauses. But around 72, 73, there came this sort of hybrid partial pollution exclusion clause, often referred to as the sudden and accidental clause. There's tons of litigation over sudden and accidental clauses. There's CLEs just on that topic. It varies from state to state. It's very state specific on how different states have interpreted what that clause means. But from about 73 to around 1985 or 1986, there were these sort of partial or hybrid pollution, sudden and accidental pollution policies. So maybe there's coverage for pollution, maybe there's not, depends on the facts, depends on how the state law interprets sudden and accidental in those policies. But anything from like 1986 forward, any general liability policy in all likelihood is going to have a pollution exclusion. That's why lawyers that do a lot of this work love to try to get back and find those older policies. So at least one of the things you don't have to get around is the pollution exclusion clause, and you get to address that. I don't want to get people's hopes up unrealistically. I'm not taking sides, but the pollution exclusion clause is not the only exclusion clause or only clause within the policy that the carrier may contend that the insured, the company doesn't get coverage for. So there's other exclusions, and there's a lot of them. And so it's good if you think you have a shot at those issues to think through that. Another insurance thing I want to just talk about briefly is the duty to defend versus the duty to indemnify. The duty to defend is broader than the duty to indemnify. That's important So it means it's easier to trigger the duty to defend. That's important because some environmental cases can go on for 5 or 10. I've in one now that looks like it's going to head north of 15 years of litigation off and on. It's nice to have a carrier pay for those defenses as opposed to the company if you're in a situation where you can get that accomplished. Also, another question that comes up with some policies is, does the policy erode? Another issue is, are there, if you're lucky enough to find general liability policies, can you find some excess policies? And the excess policies will have a lot of issues similar to the ones I've talked about. They'll have exclusions as well. So you have to go through the same process. But if you're trying to piece together a claim for insurance coverage, then it's better to have these, define these, and to go through this process than to not have access to them or go through them. If you're lucky enough to find the policies, to have the policies, to have an argument that you've triggered the policies and you can get around some of the exclusions, you have general liability policies and excess policies over a period of time, then you'll get to this type of allocation, not a super fund allocation, allocation as among the different insurance policies. And there's sort of two routes here, big picture, an all sums way and the pro rata way. Different states have different ways of interpreting those. One way is more pro-insurance company. One way is more pro-insured. My only point is putting those on the checklist is that you think through those because that will help you know whether you do or don't have coverage. A separate rabbit hole that I find very interesting is also some policies for the last 2 decades, maybe even 3 decades, specifically address pollution coverage. They expressly provide pollution coverage. It's also good when you're looking for policies, make sure, look hard to see if you get lucky and find one of those. I have been in a situation where that proved incredibly helpful and incredibly, lucky for the client, for the insured, actually in 2 different situations where these policies existed and the policies were found. So my point isn't that they should have them, you shouldn't have them. My point is check to see if you do have them, because if you do, they can be very helpful. My final point on insurance, and then I've got to move on, is notice to the carrier. If you think you may have a shot at insurance coverage, one of the most important things to do is to follow the requirements of the policy and get notice to the carrier. The opposite of that is going to the mediation, trying to resolve it, and then thinking to yourself, now I'll go after those insurance companies and let them know about this and see if I get some money. Much better practice when it's appropriate to give notice to the carrier in advance of your mediation. Okay, next secret word is fact. The next secret word is fact. Please click that on your screen. Please click fact. The secret word is fact. I'll give you a minute to do that, which will give me a minute to drink some tea. Okay, the secret word is fact. I'm going to move on, but please click fact. So the next thing I want to talk about is contractual indemnity, and I don't have a lot of time to talk about this. Plus, I find it incredibly confusing. So I want to flag it and not impress you with what I know. But it's also because it varies a lot. So here I'm talking about contractual indemnity, but not in the insurance context. I'm talking about contractual indemnity. Again, going back to the hypothetical at the beginning about property owner A and property owner B. Well, when Nuco bought from the manufacturing company, surely there was a purchase and sale agreement of some type. Generally, when lawyers are helping a company buy from a manufacturing facility or former manufacturer, they put in some form of indemnity in the indemnity agreement, in the purchase and sale. It's good to see what that is. It's good also to see what you may get from indemnity. It's also to make sure you check whether you have notice obligations under that indemnity agreement. A separate thing is in commercial leases, in the commercial context, commercial leases between landlord and tenants. Sometimes the tenant will have an obligation in the lease to indemnify the landlord if there's a spill of, say, PCE or some solvent from a dry cleaner that's in a strip center. It's good to know what's in the commercial lease. Often there's an obligation for indemnity. Sometimes in those leases, by the way, there's an obligation for the tenant to carry the landlord as an additional insured. So there might be some other insurance out there as well. It's really good to run that to ground again and deal with notice before you go to a mediation. So now contribution, and I'm going to give this short shrift because there's another topic I want to get into before I run out of time for question and answer. CERCLA has contribution built into it by statute, but it's very prescriptive. I find it complicated. Common law also has contribution, as I talked about at the outset. There may well be common law claims, so you may have common law contribution arguments. I find those complicated as well. One, they vary from state to state. There's a lot of differences in state law, common law, contribution. And so these topics are complex. I can't go into them in detail. I just want to flag them because they're important to really think through in advance of the mediation. Okay, now we're at my favorite topic of what I love to talk about. And that is, what if you don't resolve your case at mediation? Or thinking about if you don't resolve your case at mediation in advance of the mediation. I've just written an article. It's supposedly going to be published in the next week or two. I'm kind of waiting for the publisher to clarify. I call it Increasing the Likelihood of Data-Based Resolution During Mediation, Knowing and Understanding Your BATNA. Yes, I know I need to work on shorter titles. Sorry. If you're interested in the article, I'll talk more about it at the end. But I'd be happy to send that to anybody that's interested. But let me talk about this conceptually, because I think this is just so important. In advance of the mediation, what I urge parties to do is think about what if a settlement isn't reached. Think about what is your best alternative if you have to litigate. If you don't resolve at the mediation, what is your best alternative if you litigate? And trial lawyers, you got to be realistic here. What's your best alternative? And you have to swallow some humble pride if that's what it takes. But you need to think through, what is your worst alternative? What's your client's worst alternative if you have to litigate? And you should try to cost those out. Look at attorney's fees, look at damages, remediations, one lawsuit, multiple lawsuits. It really pays dividends to think this through. Well, why? Why do all this? It's so you have something to compare your offer that you get at the mediation to. If you get offered $1 million at a mediation, well, gosh, that sounds great. At 3:30, the mediator finally comes in and says, we're going to get you to $1 million today. That may be great. That may not be. Do you want to take that? Do you not want to take the $1 million? You have to know the $1 million in context. If you think you're the plaintiff and you think you are definitely going to win somewhere between $10 and $100 million in the lawsuit if you have to go forward, you're probably not going to be very impressed with $1 million. If you were thinking on your best day you're going to get $500,000 if you have to sue, and it's going to cost you $1 million in legal fees, well, the $1 million settlement looks pretty darn good. My point is, the reason you do these things is you need to know in a sort of data-driven sense. You need a number. You need some numbers, some context to know. Do you settle or do you walk away? Do you want to take the offer at the mediation or do you want to walk away? Also, do you want to take the settlement and feel good about it, or do you want to walk away and feel like you made the right decision? What you need to know to be able to do that is in advance of the mediation. I say in advance because it's complicated and it takes time to figure out. You need to figure out your BATNA, your best alternative to a negotiated agreement. What is your BATNA? Also, it's helpful to know your WATNA, your worst alternative to a negotiated agreement. If you know those, then you have context to help you decide based on data, on information, whether you should walk away or whether you should take the offer. Those take time to assess. Again, I'm writing an article about that. If you want to see it, I love talking about this BATNA, WATNA stuff because I think it's just so informative. It helps people go into the mediation with a much better idea of what is and is not a good result. The mediation is not the place to go figure out what is a good result and what is not a good result. In terms of offers, you should have that calculated so you know your walkaway number or your take it number. So you know, then you hone in if the numbers get good and it's your take it number, then you start working on the release and all the other types of issues that are important. Okay, we're running out of time. I wanted to talk about, as I said several times, I really do love talking about this topic. 3 of these 4 links that are in the PowerPoint, the slide deck, are to other PowerPoints or articles, ones in Law 360, where I talk about this same topic, the concept, the importance of the pre-mediation preparation for environmental disputes before you go into the mediation. So feel free to look at those. But one of these 4 is a little bit different. It's also dealing with dispute resolution, but in the settlement counsel role. As I said, I really, really like to work with clients, to work with people, to work with parties, to help resolve disputes. Anyway, I want to take questions, but I will just say that at the end, on the final slide, there's contact information. If you want to talk about what my article or want to talk about mediation generally, environmental stuff generally, feel free to contact me through my Thompson Coburn stuff. If you're looking for me more as a neutral, I think it's more appropriate probably to contact me through Miles Mediation and Arbitration. But I would love to hear from you. I'd love to talk with you. I do want to take a couple minutes for questions. I see there's one. So the question, and I apologize, I can't tell if everybody else can see the question that's in the Q and answer box, but it's basically how much do you engage the other side when you're trying to understand the basic facts, contaminants of concern, theories of liability, groundwater direction. I think the answer is, and I hate to sound like a lawyer, it varies. If you have a relationship with the other side, and obviously if you're talking pre-litigation, you probably do have that relationship. It's good to start talking through those things. I think the more engagement you can have, the less surprises that you have at the mediation. The flip side is, if you learn all this for the first time at the mediation, you're probably not going to have gotten much out of the mediation. And that, I think, is important. So I think it's good to test those issues, push those issues. I think it's a great question. Try to find that out as best you can. Sometimes you'll go to mediations where some of that information will be in publicly available documents. For goodness sakes, it's definitely helpful to have looked at those and understand those before you go in. Not just how you're going to argue it as an advocate, but try to think, how is the other side going to argue this? So you can start thinking of your responses, a couple chess moves down the road. I'm looking to see if there's any other questions. All right, well, I will just say I've given this talk before. Interestingly, I gave it at Washington University School of Law to an environmental class. And the students had a million questions, which I loved. Okay, so a question is, what are the main reasons mediation fail? I think it's usually a lack of information, a lack of preparedness. A lot of times, complicated cases take more than one round of mediation. Some of the most complicated, larger environmental disputes I've had are ones where we needed to have the mediator engaged and then re-engaged 3, 4, 5, 6, 7 times. I think you should sometimes plan on that because it's very, very important. Another question is, what have been the most effective tactics in large Superfund sites with hundreds of PRPs? Well, I can, and excuse me 1 second. Sorry, this darn cold. I apologize. I think generally when there's hundreds of parties, either the government or a government contractor or the PRPs together have tried to get together. And I've seen this fail, honestly, just fail miserably and spend colossal amounts of money by attorneys on attorneys' fees and get nowhere on the site itself towards the cleanup, which is just, if you look at it from a societal, philosophical point of view, just sort of a waste. Good for lawyers, but just lawyer jokes aside, it's not a positive thing. It's hard, but I think when the government works with the private parties to force the PRPs, when there's hundreds of them to talk, it can be very, increase the chances of it working. Another question, what are the range of costs for complex environmental mediation? Well, that varies widely. I think a day of mediation, I don't know. I didn't expect that. It's a very good question. It's probably the one I should be able to do off the back of the envelope. I'm thinking a day of mediation is probably 5,000, 10,000, maybe less. Maybe if there's a governmental discount, maybe less. But I think that's probably the range, somewhere between 5,000 to 10,000. I'm just sort of thinking out loud and crunching some numbers. Generally, the parties share that, so per party might be 2,000 or 3,000. It might be a little more, it might be less. That's the range for the cost of mediation. And thank you for that question. I see I'm running over. I hope I've said this already. I really, really like talking about these topics. I hope you'll feel free to reach out to me and we'll continue the dialogue. If there are any other questions that I missed in the Q&A, I'll try to answer those in writing afterwards. I want to just thank everybody. I would appreciate feedback on the talk. Apparently that's for CLE, but I appreciate it as well. I do like work with parties to resolve disputes, and I love talking about it. So thank you very much. Have a good rest of your day.